You're welcome back. This is Newsfile, and this edition is dedicated to the memory of Kojo Bafo Echampong Kaba, who visited Joy FM or the multimedia premises for the last time last night and couldn't enter his own studios where he used to do his job. He was at the car park and went back now at the forecourt of the State House, and people are paying their last respects to him. We continue. We're going to now examine the letter written by Madame Charlotte Osei and leaked to the media. But this is also some of your messages. And Jody is a lawyer, and he says the only reason this is playing up in the public domain is because a parallel track was opened with the cloned petition to Iyoko. Okay, so I think that explains.
He has a point.
Why we know the issues already in the public domain. Yeah. Because as we know, it was first triggered at Iyoko, and then the petition was sent to Iyoko, and then response was called for, and the commissioner, the chairperson, sent her response to the Iyoko, you know, and all these were leaked. I think even before the petition had gone out or so. So that's how come we all know about what the issues are.
See, something I found that even strange, that when she became aware that a petition has already been sent to the office of the president, triggering Article 146, why she went ahead to
how do you know she became aware? That letter, the petition was dated the same day. We don't know when they were delivered, to which office, at what time.
Okay.
Okay.
You are saying she should have refused to reply to Iyoko.
I wonder why people would have said. In any case, the petition, the same petition, word for word, paragraph for paragraph, and the petition contained criminal acts, allegations of criminality, and were sent to Iyoko. When Iyoko said, "Look, come and answer these responses," you are suggesting that she should have said no, because I've heard another wife's gone. But the same people would have.
But respectfully, I agree with him. I think Georgina Opoku-Amankwa, the deputy commissioner, one of the deputy commissioners, I think she did that, right?
No, I'm not sure about that.
She was required to do certain acts. No, and she said because the process is duly.
Her response was also all over the place. Yes. That it had been sent to Council of State as well as Iyoko. I have a copy. I intercepted it.
Okay. But but if I found myself in a position where a petition against my client is sent to the presidency for 146 and the same is at Iyoko, I will not respond to you.
Yeah, but I'm saying that how do you know?
There are two different tracks. The point is, when you are in criminal danger, you don't take chances.
Okay.
You have to ensure that it's an insurance. Just do your best.
No, but this is circumscribed.
No, the reason is this. 146 is a specific constitutional process.
Okay.
Iyoko is a generalized criminal process.
Yeah.
The two can continue, and there are different investigative tracks. If 146 finds something in the end, which makes you culpable, the consequence is removal.
Okay.
If Iyoko finds something in the end which is culpable, the consequence may be a criminal prosecution.
So decline.
So there are two different
decline the Iyoko route. Decline the Iyoko route.
No, they can. But
why don't you decline the Iyoko route and go to the court and stop that?
They can, but the point is, it's important for us to get the tracks. 146 is civil. It's civil constitutional.
Inquisition.
Correct, but it's civil constitutional.
Okay.
The process is not criminal. It's not criminal in character.
Okay.
And it's not intended ordinarily to endanger you per criminal imprisonment.
Okay.
Iyoko starts as a criminal process.
Right.
And it's an investigation that may culminate in prosecution. What I'm saying is the two can move together, and they are not contradictory, but they have different effects, and they both are dangerous. Therefore, when you are set with both, I will not say let's look at the letter of one, and the other should be speculated.
The option.
You know,
well,
and when you finish, I just want an opportunity to address the issue about the late President Mills and what.
Okay, so let me get this out of the way. And in the letter that she wrote, paragraph 10 says that I acknowledge receipt of your letter dated 6th day of December 2017 on the above subject, by virtue of which letter you invited me to appear before the committee set up by Her Ladyship, the Chief Justice of the Republic of Ghana. In your aforesaid letter, you inform me that the committee was set up in accordance with Article 1463, which obviously is wrong, of the 1992 Constitution to investigate the petition brought under Article 146 by the petitioners, represented by their lawyer, Mr. Maswelo Poku-Ajiman, for my removal from office as the chairperson of the Electoral Commission. I would respectfully like to make you aware of the following. So, Sophia Bochi, please, this is what we want for your attention and education. A, I have to this day not been furnished with a copy of the alleged petition. B, I was provided a statement of the allegations made against me in a letter from Her Ladyship, the Chief Justice, in which she also asked me to respond to the allegation. So, she proceeds. By letter dated the 3rd of August 2017, Her Ladyship, the Chief Justice, informed me that His Excellency the President of the Republic of Ghana had referred the said petition to Her Ladyship to determine whether or not there is a prima facie case raised by the petition pursuant to Article 1463, for which reason she requested a written response, if any, from me to the allegations contained in the petition, not the petition itself. So she said she didn't get the petition itself. By letter dated the 16th day of August 2017, I responded to Her Ladyship. I responded to Her Ladyship and attached to my letter my written response to the allegations made in the petition together with all relevant documents. Paragraph 6. Subsequent to my response to the allegations contained in the petition, I have heard no further from Her Ladyship the Chief Justice. Paragraph 7. I would appreciate being furnished with a copy of the alleged petition to enable me seek the requisite legal advice. Is she entitled to request for that?
Well, first of all, I'll reiterate the caveat that we started with, that I have no knowledge of any document of the committee, and whatever you have read on from, I still pretend I have no knowledge of that. What I speak of is general education of things, because as far as we're concerned, we're not supposed to know what you're reading from.
That's right.
So, generally speaking, from the standpoint of administrative or quasi-judicial hearings, which combines administrative and judicial proceedings, normally persons who are appearing before these bodies are given copies of the complaint that form the basis for the invitation.
So she's entitled.
So yes, so ordinarily the secretariat of the committee, the expectation is that it would have done that.
Okay, then number 2.
Correct.
Number 2, I would also appreciate clarification as to the composition and terms of reference of the committee. Can she demand to know the composition and the terms of reference of the committee?
Absolutely. There is, you have to, persons are entitled to know the persons who are conducting the hearing in respect of which they are charged. As I said, when your right is an issue, especially in this particular case, when you are, when there's a hearing against you and you are appearing before these persons, you are entitled to know who these persons are. If you appear before them, ordinarily the expectation is that once you appear before them, somehow you get to know who they are. But if you ask as a deliberate request, the expectation is that this can be secret.
Okay.
Let me just say something about that. You see, the way I read the Constitution, the committee's job, like you initially indicated, is dual: administrative, quasi-judicial. But essentially, it says to investigate.
It says 7, clause 7.
Yes.
The committee appointed under clause 6
yes.
of this article
yes.
shall inquire into the petition,
yes.
and recommend to the president whether the Chief Justice ought to be removed. Okay, so this is in respect of the Chief Justice. In respect of the others, it says
the same thing.
Clause 5. The committee appointed under clause 4 of this article shall investigate
yes.
the complaint and shall make its recommendations to the Chief Justice, who shall forward it to the president.
Precisely. So my argument reading this is that an investigation by a committee can actually take place sometimes without even hearing a particular party. But it might be useful to hear a party But you can't bind them to a specific approach that all of them must come and sit as a panel, then you will come and then appear before them. Right. If it's a committee investigating, they may decide that 3 of you are lawyers, judges. Your competence is in hearing the legal arguments. Right. He is an accountant. His competence is in examining the books of account to advise us. He is an auditor. His competence is in auditing. So anything that has to do with auditing, go and do that work and give us a report.
In fact, we are not disagreed at all.
So,
yes.
so
we are on the same page.
So this is what she's asking.
Yes.
To know the membership.
Right. But what I'm saying is, what he's saying.
Let me conclude on that. So, question is the person entitled to know
the composition?
The composition. The Constitution doesn't say so. All the Constitution says is that the person is entitled to be heard.
Must the Constitution say so?
No, it says so.
Must the Constitution say that you should know the
kangaroo court?
But let me just, I will not use that. No, I think you've used the very...
I thought right from the beginning.
No, you've used the very
good right from the beginning. I said that in my case, I'm going to pay attention to what the law says.
No, but this is what the law says.
Okay, so you just hold on. Yes, continue.
This is important for clarification. This is what the law says. We are not disagreed. Yeah. My senior friend. We're not disagreed on this matter at all. But let's read the Constitution in the entirety. Article 23, which deals with administrative justice, when it comes to the administrative component, says administrative bodies must act with fairness. Now, part of the reason why, per extrapolation, in terms of interpretation, you will come to the conclusion that the Constitution requires you knowing the people who hear your matter, is that you may have a procedural objection.
But it's not a hearing.
No, I know. No,
it's not a hearing.
No, I know. It is not a hearing. No, it is not a hearing.
Yes.
But even in terms of the investigation, you may have a procedural objection which may not culminate in someone being changed, but which may culminate in you raising an objection for the purposes of the record. So that in the event of some finding, and you want to bring out issues. In other words, there must be some transparency. The transparency is not designed for you necessarily to go there, as it were, just to create problems. But it's designed to create...
I think your point is that it's clear now. Is she also entitled to know the terms of reference of the committee?
That may be a tricky one. It may be a tricky one because she's only entitled to know things affecting her investigation. I mean, things affecting her rights. So they've written to you. Is it part of the remit for you to investigate things concerning me? That she can ask. But beyond that, asking what are the ancillary obligations of the committee, what are the other functions and the purposes for the committee, that would be asking too much. It's not really your remit.
Okay, so she concluded the letter by now saying that I will honor the invitation to appear at the scheduled time and date, but this is without prejudice to my constitutional and legal rights. I look forward to your addressing the matters that I have raised in this letter. Yours sincerely, Charlotte Osei. So your quick points, and then
my quick point is this: one, I don't believe that there is any right to know every member of the committee, but I believe that if there's a letter to Charlotte inviting her to appear before the committee, when she gets there, she becomes entitled to know every single member of the committee. Because you invited me to appear before the committee. 2 members of the committee don't constitute the committee. 3 members of the committee don't constitute the committee. If the letter had said that the committee has decided that you should appear before 2 of its members, so at this location on this day, they will be available to meet you. It presupposes that they've structured their work in such a way that they have assigned 2 members to hear you on any issue that the committee wants evidence.
Thank you.
So the problem with this whole thing is that there are no clear
cut rules. But it's also important
there's just a framework. And for me, in this case, the framework is an investigation.
When there are no clear-cut rules, like you suggest, in such situation, what do you do? What do you do? It's a question, please. What do you do when there are no clear-cut rules for this specific situation? Which is a constitutional inquiry, like a constitutional civil inquiry. What do you do?
The
controlling
word here is investigation. And I'm saying that it is perfectly possible for the committee to say that on the basis of documentary evidence before us, we probably don't even want to hear any witness, and we can produce a report for the president. If it is paper, if it is procurement, the allegation is that you did procurement, and then I go to the National Procurement Authority, say, produce all the documents regarding this particular procurement. If it's our payment, and we call the accounts officers at the EC and say, generate all the information about how the payments were done, who processed it, who signed it, and etc. And if we have enough evidence, we don't want to hear you. We know your signature because when you everything is with us. Would you have disturbed
the requirements of rules of natural justice?
Thank you. Good question.
No.
It's a higher form.
Hearing is different.
Yes, but it's not at the point. It's a higher investigation. It's a higher form of it's a higher form of hearing. It's a higher form of hearing. No, respectfully, this is a very It's the epicenter of our constitutional rule. Yeah. And we are dealing with history at this stage. Yeah. This is going to set precedent for years to come. Yeah. And that's why I'm glad we're all trying to discuss this dispassionately. Yeah. The point is this. This is a higher form of hearing. It's a higher form of investigation. Mind you, when the investigation concludes and the recommendations are given to the Chief Justice as the one who sets it up, and she forwards it to the President has no discretion in the matter.
The Constitution says so.
At that stage, the findings of the committee will actually constitute a holding or a decision. Yeah. A decision that binds the President to take a decision, or rather to take a step or an action in ensuring that she's removed. So this is complete hearing, but it's a hearing characterized and couched in the character of an investigation. And that's what I'm saying. And mind you, per the authorities of, per law, hearing doesn't have to only be oral. We can have documentary hearing. So you're right on that. Yeah. So we can have exchanges of evidence, back and forth. Yeah. That in itself is hearing.
Right.
And I'm saying putting that in the totality of the context of fairness under Article 23, among other things in the Constitution, I understand what you're saying, but I think that when a request is made about who the people who are investigating me are, I think it is only fair that I know them, because I may have issue with somebody who may be involved in that. And while I may not be able to raise
conflict of interest situations,
while I may not be able to raise objection to change one or two of them, for example, even per their record, it's important that that's all. I'm just saying, moving forward.
All right, thank you. Thank you. Okay, I'm coming to all of you briefly to canvass in 2 minutes what your concluding remarks will be about this, and then we'll move on to the next issue. So, start with you.
I think that the letter to her was that appear before this committee. My position is that letter entitles her to know who the members of the committee are.
Okay.
If they had just said appear before Mr. X, the committee has asked Mr. X to meet you on this issue. That's the difference.
So she's entitled to ask for it.
And secondly, I think that we should pay attention to nomenclature.
Okay.
In the case of this investigation, the word that the Constitution uses is investigate.
Right.
In the case of the Chief Justice, the word that it uses is inquiry. And we know all the rules regarding committees of inquiry and the process of inquiry and the fact that it's quasi-judicial and all the guarantees. But for an investigation, we all know practically what an investigation is. It is to ascertain facts. And I can use any mechanism to ascertain the facts. Whether I like you, I don't like you, may be immaterial. So
no, but you cannot use any mechanism. Yes. You can use a mechanism that conforms with law.
Yes, when I say any mechanism, I don't mean that you can use criminal, mechanism. I mean the state trying to find out.
I mean you can't use extrajudicial mechanisms.
Yes, but in this case, it's not even a judicial process, right. So you can't even use the word extrajudicial. It is an investigation.
Okay,
trying
thank you.
To ascertain facts.
Thank you.
So for me, the key thing in this whole process is constitutional lawyers should begin to debate these issues to see whether we can develop.
You wanted to say something about
Professor Mills.
Yeah, Professor Mills and Georgina Wood's petition against Georgina Wood.
Yes. The suggestion that the late President Mills may have acted unconstitutionally is not well-founded. Now, if somebody petitions, there are many things that can happen. One is that the person receiving the petition can engage the person petitioning. So what are the contents
the
of
Constitution says in consultation.
No,
but the Constitution said consultation with the Council of State. Set up a committee.
No.
It is called
let's have a dialogue.
How?
No, listen carefully.
No, he's talking about backroom, you know,
Yes,
the politics
you
of
can
it.
bring a petition to me.
The political management.
Excuse me.
It's dangerous.
Oh, in court. In court. Sometimes you want to initiate an action. And sometimes the judges are you sure you want to proceed with this matter? Are you getting the situation?
Or can't you settle
Yeah,
this?
can't you deal with this issue?
Okay. That is because they are allowed to.
Alternative dispute mechanism. Is that what you are talking about?
Somebody.
Article 146.
I actually want to support something.
Yes.
No, because I think it's creating more minefield difficulty. The difficulty here is this. If the president receives a petition,
Yes.
the president has no discretion.
Thank you.
So, no, 1 second, no, but I just want to support something. The president has no discretion, and the president even has no mandate to try and settle the matter.
No.
But the question is whether the president can characterize something he has received as a petition. That is where the discretion comes in. So the president has a preliminary judgment to make that this document I'm holding constitutes a petition. And that one involves, we've discussed that here actually in the past, that if I receive something that has no names, that has no signature, that is not identifiable.
Yes.
So those, no, but I'm just saying,
that's
that's
not
what I'm
primary
saying.
facie determination.
No, at that stage, you haven't gotten to petition yet.
Thank you.
But once we get to the stage of petition, and say this is a petition, you can't stop the process. The Constitution says as soon as you receive it, forward it to the chief.
That's the clarity.
So I just want to say, respectfully, and I hope the late Chief Justice, the late President, did not receive a petition at that time. But if he didn't receive a petition,
well, there was an individual
so
to it, so there's no question about whether it was a petition or not. Your 2 minutes is gone. Please, can we hear from Nessa? Thank you. No, you have been assisted properly. Yes. So, in conclusion, what do you also have to say about this whole process? I mean, what would be your concluding remarks?
Of course, I mean, the process, we all agree, ought to go forward to its logical conclusion. But some points that the eminent journalist who has all the expertise in intercepting documentation made. I understand that the petitioners have not whittled down to 2 at all, and that they are indeed 17.
Who is telling you that?
Well, that's the understanding that I have.
The petitioners are 2. They have been named.
There are 17,
Ampofu and
as is contained in the original documentation. and of course, I mean, ultimately, all these
it means
play
that
out
this man
for
has
all
been
of
given
us.
privileged information.
No.
He's speaking about things in camera.
So ultimately, it will play out, and then we will see as to whether because the impression that I get being created out there is that 17 people were initially said to have signed the petition. So at what point did he get to 2? At what point?
Okay. Right.
So let's see how it goes.
I can say maybe I know as much as Kweku knows. When Kweku says that the petitioners are 2, and that they haven't signed on behalf of any other, my part of my job through my research, what I can also say is that is what it is, and I've actually named the so-called the petitioners. Right. So that's where you want us to take it now. Mr. Abuchi, the question that is coming on, each of you 2 minutes, and then we take a break and come to the next issues. The question that is coming on is that and I think I asked him about it, and I sought to ask Ayariga too. When the Constitution says you bring a petition on questions of stated misbehavior and or incompetence or ill health or mental situation, what we understand is that 6 issues have received prima facie determination. The questions other people are asking is that we all know these things. So among the 6, the questions that are being asked is, how does the cancellation of a fraudulently awarded contract to the STL, for example, constitute a ground for impeachment? There's a cancellation of a contract to a party. Will that fit in Article 146? How does the cancellation of a fraudulently awarded contract to STL amount to stated misbehavior or incompetence? For example, that one of the issues to be determined is the engagement of a law firm or solicitors. So how does the engagement of a law firm or solicitors constitute ground for impeachment? I mean, these are questions that are coming up.
Well, I haven't seen a copy of the petition.
We have seen them. They went to Yoko. It's all over the place.
I haven't seen them. So,
okay, but have you seen the complaint to Yoko?
I haven't seen it.
That's a good one.
Okay, go on.
I haven't seen anything. So I haven't seen the petition. I am therefore not able to tell how the facts were woven. Therefore, awarding a contract per se cannot be misbehavior. Engaging a law firm on the face of it will not be misbehavior. But if the facts are woven in a way as to suggest acts that are not contemplated in the line of standard practice of awarding contracts, if facts are woven in a way as to suggest issues of, say, conflict of interest, issues of corruption, other allegations, if the facts are saying those, then that is where you can have a simple, benign thing, like the award of contract becoming problematic, the engagement of a law firm becoming problematic. So I haven't seen the petition, and I'll say, and therefore I'm unable to comment on how that is woven to suggest that. But my suspicion is it may have been tailored in that particular direction, that they are suggesting things untoward. And I think we had a lot of stuff on radio, especially this June, July, thereabout, when the allegations were coming out. We had all kinds of things on radio. I suspect that is how
the claims on that contract was that, you know, it had been cancelled. And the suggestion was that something wrong had been done. And then the information factually was put out that it had actually been cancelled because it had been, it was to be awarded for $24 million. And then she came in and ensured it was awarded for $2.7 million. So there was a reduction instead.
Which may suggest good behavior. But again, I haven't seen the details. So I'll just say at this stage that on the face of it, these are benign standard things to do when a person is in office in the position in which she was. However, putting it in the character of a petition, the suspicion is I'm sure they've woven the facts to suggest that there were untoward things that may have.
Thank you. 2 minutes.
Yeah, you see, we're all challenged. And I suspect all the respondents might be challenged. The same, even those of us who are outside the whole thing are suffering. See, if you see this 6 allegations where CJ has made prima facie case, they are listed. Okay? The difficulty, I'm on my own trying to deduct who these 6 are relative to. Okay? I don't know. It's allegation number 5, engagement of sorry at law. Allegation number 6, contract to STL. Allegation number 7, contract for partition 1 of new office block. Contract number 4, allegation of number 8, prefab district office contract. Allegation number 18, Dream Mobile website contract. Allegation number 27, quasi contract for development of new logo, which I vehemently opposed and criticized, if you recall. Now, I can do my own deduction and see.
We saw it, we liked it, we picked it.
Yes, and we all condemned it. But you see, you are not able to tell which of the respondents, all these 6, is this 6 going for one of the respondents or all of them? Because I've cited this, I'm able to make a deduction.
I don't understand. There is 1 respondent for 1 petition, and there are 2 respondents for another petition. Is that not so?
Yes, but what I'm talking about, prima facie, the cases that have been taken out. Because you see, the 27 we talk about, let's not forget, it's 27 allegations made against the chairperson.
Yes.
That's what we know.
Yes.
There are other allegations against the other 2 respondents.
Those have not been leaked also, so we don't know.
Well, I have them.
Okay.
But they don't number 27.
Yes,
we did, yes. They don't number 27 in terms of precision.
Okay.
So when we talk 27 minus 21, it means we are talking about the one that went against the chairperson.
Okay.
Now here I see 6. But you see, allegation number 6, and you were having that difficulty, contract with STL. I wonder, prima facie against which of the respondents, if you know the record and the history. We don't know, but I suspect the respondents now know because they went in.
I don't understand. When you say if you know the record and the history, what do you mean?
Oh, for instance, the STLT was done before the chairperson became chairperson of EC.
Okay, but is she not the one we are told ensured the price
she
was
came
reduced?
to ask questions about it, the propriety and things.
So she's connected?
Yeah, she's connected. If you connect her to this, she wins, hands down. Head or tail, she wins. That's the point.
If there's information that, and I'm not saying that may have happened, if there's information that reducing it from the 24 million to the 7.2 or 5 million, something else.
No, but the
happened,
person who signed,
you know, somebody benefited.
One of those who
reduction.
signed the contract, it's documented, saying that, well, he thought he was signing a maintenance contract, and that in the case, when it comes to procurement, he has no knowledge. Okay? Where the contract should have been generated from, the finance department.
Right.
And I'm going to a minefield.
Your 2 minutes is done.
I'm going to a minefield.
Your 2 minutes. Your 2 minutes.
I hear you. I will stop there.
Thank you very much. And we've spent quite some time on this. And by way of precedent, this will be the third time that such an impeachment process is engineered against commissioners of a constitutional, independent constitutional body. These are used all the time against judges, but for these classes of people, that this will be the third time. The first was in 1999 against, there was a Justice Sakwa committee for the removal of Dr. Jacob Emmanuel Opong, a deputy chairperson of the NCCE, and eventually he was removed. He wasn't happy about it. He went to court, the Supreme Court, but he lost. And then there was the 2014 one, which ended in November 2015, the Strad one. So this is the third that we are having. But a third involving three. That is huge. We'll take our very final break.
I have a message for
and then
one of the drivers. I got to.
We are talking about one being NDC.
Yes, I have a message for him.
Oh, okay. Interesting. Interesting. But it is possible. It is possible that they are two, but they have deposed to the petition on behalf of the others. We do it in court.
There is no such.
You can take a number of.
But I'm telling you, there's no such.
And then one deposing for all of them.
No, there's no such record.
Okay.
Because that record must be disclosed to the respondents.
Okay.
That if you are
we'll
told, you know,
it's
very
17, final break.
and
we'll return, and we are doing the show until 12:30. We'll be right back.
Really?